Good afternoon, everybody. It is about 3:03, and I'd like to bring the Kane County Committee of the Whole. Would you please call the roll?
Allen, Arroyo, we do see you online, but you are muted. Bates,
Bates here.
Berman,
Berman's here.
Doherty, Garcia,
here.
Gripe, Gums, Iqbal, Juby, Caius, Leonard, Lewis, Linder,
Linder here.
Molina, Genesis,
Genesis here.
Roth, Sanchez, Strathman,
Strathman here.
Surges, Tarver, Tepe,
Tepe here.
Williams, Young, Pirog.
I'm here.
Do not have an in-person.
But we are not going to be voting on anything, so this meeting can continue, and we'll welcome people in as they finish their other meeting. We have no remote attendance requests. Alex? You're interested in attending remotely. You are welcomed in. I don't see any other board members up there.
I'm here, but
Oh, okay. I'm sorry. I had the wrong glasses on. I can see now.
but my excuse is giving a talk for the referendum at 5 o'clock. I don't know if that's an
Oh,
excuse.
no, that's
excuse or
totally,
not.
no, you're welcomed in. This is not a decision-making board, this committee. This is to listen to good information. So you are welcome.
Okay.
And who else are we looking at? Myrna, I don't see her name. I don't see the bottom. I see Cheryl. I see Terry. I see Alex. I see presenter. Oh, okay. Okay. And Myrna, you are welcomed as well.
Thank you, Madam Chair.
There you are. Very good. Oh, now I see you. There you are. Okay, very good. Okay, welcome. So we have two speakers today. Oh, we have to do the Pledge of Allegiance. Beth, would you mind?
Pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
We do not have a quorum, so we can't approve the minutes. So we'll continue on with that. If we have quorum, we can do that at the end of the meeting. We have, again, two speakers for public comment. The first speaker is Denise Gorlick. Denise? And ma'am, you have 3 minutes.
It'll be less than 3 minutes. I didn't have long to write it. Good afternoon, Denise Gorlick, St. Charles. On February 27th, I walked into the Kane County Courthouse to witness the preliminary hearing of Alejandro Cota, the undocumented immigrant who is charged with the horrific stabbing deaths of a mother and her young son in Geneva. What I saw that day was an embarrassment to justice. Let me remind you of who Alejandro Cota is: a man with a 33-year criminal history, a man convicted of armed robbery, driving offenses, domestic violence, and harassment, a man who was deported in 2012, yet somehow, inexplicably, is back in our community standing trial for the brutal murders of innocent people. How does this happen? How does a man with this kind of criminal record continue to slip through the cracks and remain in our county, let alone our country? There were 19 cases on the docket that day, with defendants accused of crimes ranging from first-degree murder to aggravated battery against a child under 13, an attack so severe it caused permanent disability. I saw cases involving convicted felons caught with illegal firearms gang members with guns in their vehicles, and criminals who had inflicted damage costing over $100,000. And yet I saw chaos instead of a system that demands accountability. I saw defendants who had not bothered to contact their attorneys, public defenders scrambling for basic information like phone numbers of the very people they were defending, multiple cases being conducted over Zoom, stripping the proceedings of any real sense of responsibility. Instead of protecting the innocent, the Kane County judicial system appeared to me to function at the pleasure of the criminals and not the victims. That's it.
Thank you. The next speaker is Ginger Romano.
Hi there.
Hi,
Um,
Ginger.
Ginger Romano. I'm a Kane County resident, taxpayer. Okay, so I want to,
You can bring down that,
More?
there you go.
okay, thank you. I want to share my experience watching courtroom business as someone from the outside looking in. I took my seat in the gallery to observe and await the outcome of a certain criminal murder case. There were 19 cases to be heard that morning, beginning at 9 a.m. I found it interesting that one of the 14 cases I observed, only one had a conviction. All of the rest, including the criminal murder case, were continued for what it seemed to be one perceived excuse or another. The prosecutors or defendants either not having their act together, as in they hadn't taken a look at the case, waiting on information that was forthcoming, or they didn't have enough information and needed to do more research. It was one after the other with, we need to move the hearing to another day. Some of these cases were kicked down the road quite a few times already. The judge and attorneys were amicable and matter of fact, and the cases rolled on one after the other. Oh, you can't do this date or time? Okay, what would you like? Next, and on it went. Is this how our tax dollars are spent? It seems very inefficient to me that there were a few cut and dried cases that were continued for reasons unknown to me. The criminal murder case was also postponed due to the state's attorney representing the people didn't have what I remembered having done her due diligence for the case, and it too was continued. The alleged murderer then asked to have his next hearing on Zoom, of which the judge politely but firmly told him that she is the one that decides that, but she would allow the request for that time. At least she chose to keep him in custody. He has since had another Zoom hearing and apparently was continued again. This causes my skeptical mind to wonder if the man is even still held here in Kane County. Continuing these cases for months on end does no one any good and a bad use of taxpayer dollars. Not to mention the number of interpreters that are being paid so that the defendants can comprehend what is being said in the courtroom. I'd like the state's attorney and judicial partners to stop playing victim and put action into getting this Safety Act abolished and go back to what was working. Stop making the criminals the victims and make them appropriately pay for the consequences of their actions in a timely manner, and stop punishing the law-abiding taxpayer. When will justice be served to the egregious case of the man that murdered the woman and her 13-year-old son in their own home? Thank you.
I do believe that concludes our public comment. I'm not aware of any other speakers. No, there's no other speakers. So thank you both for coming. As I always said, your words are always welcomed. So now we're doing a presentation regarding Pretrial Fairness Act. Presenters are going to include our Chief Judge, Sheriff Hayne, Court Services, Circuit Clerk, the Public Defender, and our State's Attorney. So I will turn this over to John Frank, since he's doing tech support right here and can introduce the speakers.
So the purpose of the discussion today is to talk about the Pretrial Fairness Act and also the effect that it's had on our court system.
Jamie, could you get just a little closer to the mic? Is it on?
Yes, it's on.
Okay, that's better. Thank you.
So the Pretrial Fairness Act is something that was a part of the Safety Act. This is something that started in 2021, and this was from our Illinois legislature. It's important to note the Pretrial Fairness Act, while a part of the Safety Act, now has been dealt with differently in a third trailer bill. The crux behind the Pretrial Fairness Act is this has changed the way that we have to work in our criminal justice system in terms of now defendants no longer have bond that's put on them. Instead, they're either held because they're a danger or a willful flight, or they're released because the court has made the finding that they're not a danger or willful flight. The third trailer bill that ultimately amended the Safety Act and the Pretrial Fairness Act was done so at the request of the state's attorneys throughout King County or throughout Illinois, with the exception of 2 state's attorneys, and that was the then Cook State's Attorney and the Lake County State's Attorney. The other 100 of us advocated for change in the Pretrial Fairness Act, and there were 3 of us who were at the table, myself, Bob Berlin, and Julia Reitz, the Champaign County State's Attorney, to make the much needed changes. This law is still not perfect. We continue to go to Springfield to legislate for changes. Once this presentation is over, I'm on my way to Springfield to continue to legislate for changes. But this is a law that was created and put forth by the legislature. Now, we've been able to make some significant changes in regards to it, but it is flawed because people who should be held don't necessarily get held because of the way that it is drafted. This law then affected every single one of the departments that you're going to hear before us, because we've had to have different staffing, different ways of performing court, different everything because of the implementation of this. So at this time, I'm going to introduce Judge Julie Yetter, who is going to talk about the impact that this has had on the judiciary.
All right, I just have one slide here. Let me see if we can, if I can navigate to it. There we go. All right. And first of all, thank you for inviting us to speak to you about the PFA implementation here in King County and what we've done based upon the requirements of the law. As Ms. Mosser told you, I'm Julie Yetter. I'm an associate judge here in King County. The chief judge asked me to come and present on behalf of the judiciary today because I also was the judge who was assigned to chair the Safety Act Task Force that the judiciary implemented with the help of all of our judicial partners back in January of 2022 to begin looking into what the law required, what changes would need to be made, and how we then as a county would be able to implement those changes in a way that put us in compliance with the law, but in a way that was in a way that allowed us to be as responsible as we could with our resources and working with what we already had. So at the time, I was assigned as the judge in bond call, which means pre-Safety Act. I was the judge who heard all of those cases of every person that was arrested in the county and came before the judge. For perspective, that court call, and I was the only bond call judge in the county, that took half a day. So half of a court call. The other half of my court call was hearing all of the orders of protection petitions and hearings that were filed in the county. When we started working together, and I do want to take a minute to express how grateful I am to be part of this county and this community in working with our judicial partners. I recognize how fortunate we are that we all work well collaboratively together to try to come to solutions for issues. We don't always agree. Certainly we shouldn't, but we were always willing to sit down, work through our issues, and come up with a solution. The task force was comprised of, as I said, all the judicial partners. There were representatives from the various local police departments in Kane County, as well as members of some community foundations that also were potentially affected by the changes in the Pretrial Fairness Act, for example, Mutual Ground and some domestic violence related resources. We met bi-weekly starting in January of 2022 for well over a year and a half as an entire task force. We additionally dealt delegated, I guess, various members to different subcommittees that met and worked outside of our biweekly meetings. And that was, as we said, to review the changes to the statute, compare what those changes would require from us. And then in comparing that to the system that we had in place, identify what needed to change and make proposed changes or proposed recommendations for those changes to be implemented. With respect to the judiciary, I do want to point out that, and the reason I took the time to explain that prior to the implementation of the Pretrial Fairness Act on September 18th of 2023, as I said, bond call took half a day. It was very clear that the hearings that were going to be mandated with the timeframes in the statute were going to require that court call to expand to a full day court call. That also meant then that we didn't have another physical courtroom for the orders of protection to be heard or for bond call to be heard. Alternately, we were sharing one courtroom for both of those things. So that did require from the judiciary's perspective, we needed more space. We needed to convert one of our few meeting rooms that were left in the Judicial Center into a new courtroom to be able to accommodate the needs that the Pretrial Fairness Act imposed upon us. I do not want to take up too much of your time this afternoon because I know that the other partners who are here to speak to you have a lot of interesting information to talk to you about with respect to their specific departments. So certainly I'm going to leave it at that. And I'm going to turn this over, I believe, Ms. Mosser, should we go to Court Services? All right, I'm going to turn this over to Court Services then to talk to you next. Thank you.
Madam Chair, are we holding questions or?
I think if we'll have just one question per speaker and then we can have other questions. If there's just a question of clarification, and if not, we'll have questions after.
And I will stay till the end for questions, but if you have a question now, I'd love to hear it.
Well, my question is, bond court now takes all day. Why? Now, that's probably a 15-minute answer.
It sure is. And I'm gonna try and give you the 30-second answer because I know that you're gonna hear from some of the other departments that are gonna explain some of the process. But the short answer is we see a number of people who come in where they're not eligible to be detained under the new law, but the intent either of the police agency who's arrested them or maybe the state's attorney in communication with the police, the belief is that there are conditions, restrictive conditions of release that need to be addressed sooner, far in advance than the first court date they would get in the trial courtroom. So those cases are seen in the morning. We also see a number of people in the morning who may be arrested on warrants that have been issued. And then the detention hearings, what they involve with the discovery and the preparation for that, those occur in the afternoons. And so it has grown into a full day court call. The hearings are more involved than what you would have heard previously at a bond call. So that's the short answer. But like I said, I think you'll get your question more thoroughly answered from some of our other presenters.
Thank
Okay.
you.
Thank you.
Okay, thank you very much.
Good afternoon. My name is Latanya Hill. I'm one of the directors for Kane County Court Services. Later, Kyle Grenfell, our program manager, deputy director, will be speaking to you on behalf of Court Services. I'm going to pass this. So somewhat to answer some of your questions, this slide is going to show you the prep time and how long each of our individual departments have to invest to ensure that we are in alignment with the legislation. As you can see, our office, Court Services, we start our day at about 5:30 a.m. And that's ultimately because we have to run some background checks and do some assessments that I'll go into more detail shortly in order to get that information to our judicial partners, the state's attorney, public defender, so they're able to do the work that they do. This slide also shows you how we each ultimately have to lean and depend on each other to make sure that we follow the legislation and we're able to take care of everything that happens in first appearance call. But as you can see, court services, we are in the building and we have to cover first appearance call 365 days a year. There are no holidays. My staff, I have somebody coming in at 5:30 a.m. each of those 365 days, including Christmas Day. They're not happy about that. In order to do those assessments, to be able to make sure that first appearance call goes on. Not only do we have to do the prep work on the front side of things, we're also there during court. So we are there during the actual initial appearance. We're there for any questions anyone may have for our assessment, our risk assessments that's taken into consideration as to whether or not the judge would be able to make decision as to whether or not to detain or the state's attorney to file a motion. And then after that, we are also delegated the task of doing the intakes and then supervising those defendants or clients that are released from the initial appearance or detention hearing. As you can see here, I'm showing you numbers pre-PFA and post-PFA. So as you can see, those in green or the blue, I'm sorry, more of the turquoise blue, they were just released without any supervision. However, those in green are those clients or defendants that I talked about that once they attend that initial appearance, they are now on our caseload, my court services staff caseload, and we are monitoring conditions, doing court reminders, things of that nature, to meet the needs of the client and the court. So as you can see, alone, you have about a 1,200 increase between the PFA year and post-PFA year, just in those on community supervision. So that's a 48% increase in initial appearances released on recognizances with pretrial conditions. Okay, so that's a huge surge of defendants that court services must begin supervising immediately after court. When they appear in the first appearance court, the judge is going to tell them they need to check in with court services. We have to go through all their court orders, make sure they understand those court orders, get contact information and the like, and then we're tasked with supervising that case as long as they are in the pretrial phase of their case. That means we've had more court supervision than ever before, due to a lower proportion of defendants lingering in the jail. Because pre-PFA, there were defendants that were in the jail because they were unable to post bond, but they were also on our caseload for pretrial supervision. That meant we didn't have much to do. Now, because you have more people being released into the community, that means we have more people that we need to supervise out in our communities. So if you look at risk assessments, prior to the implementation of the PFA, we did 4,086 PSAs. That is the public safety assessment. That is a validated risk assessment used in the pretrial phase of cases. Post PFA, we're 4,550. So that is 464 more assessments with an 11% increase. Let me go back and say, we did not increase head count. So we're doing more with what we already had. We have 11 pretrial officers. I have 2 supervisors, myself and Kyle. A portion of our job is pretrial, but we also are over the administrative task of other programs within court services. We've been able to maintain it thus far, but in all actuality, you can see the increase in the work that we've had to do. Another thing that the PFA did is prior to the PFA, we were not doing the ODARA or the Ontario Domestic Assault Risk Assessment. One big piece of that legislation was really looking at how we look at those accused of domestic battery, whether they should be released in that. So as a system, we decided that court services would complete this ODARA when intimate partner violence occurred, so that information can be shared with the state's attorney to make decisions as to whether or not a motion to detain should be filed. So another thing to keep in mind, we have more court appearances immediately following court than ever. Of those that appear in court, about 90% of them are up for immediate release. Another thing, because we do all work in conjunction with one another, when there's changes by our other partners, it changes the work that we do. So I think many of you have heard that State's Attorney Mosser has implemented a unit that looks at child pornography. Well, when she is filing more cases as it relates to that, that changes the type of orders and conditions my staff are being tasked to supervise when these defendants are released into the community. So we're doing more than we were doing before, or handling more complex supervision, such as phone searches. And some of the orders has asked my pretrial officers to go out and do home visits. We were not getting these complex type of release conditions prior to the PFA. Again, we're trying to address it the best that we can with the same resources. So now I'm going to hand it over to Kyle. He's going to talk about the supervision strategy that research has found to be most effective in the pretrial stage of a case.
Good afternoon. My name is Kyle Grenfell. I'm a program manager with Kane County Court Services. I work with LaTanya on some bigger picture issues that have to deal with our pretrial services unit within court services. So on top of everything that LaTanya just mentioned that our pretrial officers do, home visits, drug testing for things that come up on a case-by-case basis, there are also things that we do for all of our clients that are on pretrial supervision. One of those is court reminders. So this is hands down the most effective thing that we can do for our pretrial clients is remind them of each and every court appearance that they have. So we have some more numbers pre and post PFA. So prior to the PFA, 1 year prior, we delivered 14,400 text messages to our clients about an upcoming court appearance. In the first year of the PFA, that number went way up. So the PFA has impacted the nature of pretrial supervision and how we manage our clients when they're out in the community. So we, this was hang on, I'm still getting used to this here. So this is an increase of 27%. The number of court reminders that we sent the first year of the PFA was an increase of 27%, or 4,121 more reminders. Now, the majority of the reminders that we send are via text. In order to do that, we have to have our pretrial officers enter in manually each and every court appearance that is upcoming in order for our automated system to work. The majority of our reminders are sent out via automated system, but we do have clients who will opt out or decline to receive court reminders that way. For those defendants, we follow up with individualized text messages the old-fashioned way. So the pretrial officer will deliver one text message by hand with their county-issued cell. Or if there's another way that the client prefers to get their court reminders, they will send it to them that way, via phone call, email, whatever works best for the client. Another change that we had to make in response to our increasing workload due to the PFA was implement something called the Release Conditions Matrix, or RCM. The Release Conditions Matrix is a decision-making tool, and it matches someone's level of risk to an appropriate level of supervision if they are released back out into the community. We did this because we were facing an increasing number of pretrial clients ordered to supervision during the first year of the PFA. There was a significant uptick in pretrial supervision being ordered. We found ourselves in a position, as did many of our justice partners here, we found ourselves in this position of needing to do more with less. We did not have extra bodies, as LaTanya said. We have not added extra headcount, yet we still needed to find a way to effectively and responsibly manage risk when people were released out into the community. To do that, we offered new levels of pretrial supervision that were matched solely to assessment-driven risk, This replaced our outdated model. We implemented it in September of last year. Before we made this big change, as pretrial supervision affects all of the other justice stakeholders we have, we shared this with the state's attorney's office. We shared this with the public defender's office. We shared this with the judiciary and the judges that we work most closely with for initial appearance court hearings. We gave them a chance to review it, ask questions, provide feedback. So this was not a solo effort. It was done in collaboration with some of our other partners. This is what it looks like here. So the release conditions matrix is going to match somebody's likelihood of success across the vertical and horizontal risk scales that you see here, which are measured on a scale of 1 to 6. The lower your score, the more likely you are to be successful if you are released back out into the community. Your risk scores are then matched to a level of supervision. The lower your level of supervision, the less intensive your supervision is. Again, this is allowing us to be more purposeful and more strategic with the increasing number of people that are placed on pretrial supervision with the same number of staff. Another change that accompanied the PFA was data sharing. Data sharing was a point of emphasis across the leadership of the task force that helped us implement the Safety Act and PFA here in Kane County. The idea behind making pretrial release decisions more accessible, more transparent, was because at the time this was being implemented, there was a lot of uncertainty, a lot of confusion about how this would play out in real time once implemented. What would be the impact on the community? So if we can make some of the data behind pretrial release decisions more acceptable, it might help with some of that. This is publicly available. We have the link up here on the slide for you. All of the credit in the world in making this goes to the Kane County IT department. They built a very user-friendly and interactive data dashboard that if you go to it will show arrests broken down by police departments, appearances broken down by the most serious offense, whether or not a petition to detain was filed. All of the relevant info and data points that we thought would be most pressing to the public, we've tried to make those as publicly available as we possibly can. Again, this was a collaborative effort. That's kind of the theme you're hearing, right? This was done with input from the state's attorney's office, the public defender, the circuit clerk, court services, as well as the judiciary. There were no guideposts that kind of guided our efforts when we were trying to come up with a public-facing data dashboard. There was no precedent, no previous examples. So we came up with one that made sense to us, but it looks like it worked because it has since been copied, almost exactly copied by some of the other circuits throughout the state of Illinois. So if you were to go to the McHenry County Circuit Clerk or the DuPage County State's Attorney's Office, the Winnebago County Probation Office, you're probably going to see a link to their pretrial data sharing dashboard. This was also copied by the Office of Statewide Pretrial Services, which provides direct pretrial risk assessments and supervision to right now 75 counties in Illinois.
Congratulations.
So this is just an example of one of the graphics that any member of the community could see if they were to go on our data dashboard. Again, you can filter it by different time windows, different departments, different charges. This is an example of what it would look like if someone were interested in just which police departments had arrested folks that were brought to initial appearance courtroom within a certain amount of time. And with that, I will step away and turn it over to the Kane County Circuit Clerk's Office, I believe.
Good afternoon, everyone. So one of the things that you've heard a lot about is the 005 courtroom, which is also bond call, which is also initial appearance court. So in 23, this gives you a little idea of what the overtime hours were for that courtroom. Just from 23 and September, October, November, December of 23, and then 24. We have a labor contract at the circuit clerk's office, and the clerks that man the courtrooms, they are under that labor contract. So this is a description or the hours of what
their regular pay and their overtime pay was for 23 and 24, just the hours. I do not have the breakdown of the dollars because we cannot break it down by courtroom. We break it down by clerk. So that's how payroll is done. So the overtime pay did increase due to the union contract. Now they are up to $45 guaranteed an hour with minimum of 3 hours. And for holiday pay, which would be 4 holidays a year, which one is Christmas, just to give you an example, is $75 an hour. Again, guaranteed 3-hour minimum. I do have from overtime from 23 was, let's see, 637. So it did double our overtime hours in 23. So that's a huge increase. Because of the PFA, we had a lot of training hours. We trained supervisors, trained staff, trained clerks. In the beginning, we had a supervisor and 2 clerks, sometimes 3 clerks in the pretrial hearings so that they can get a feel of what was required of them going forward, since it's not just used in that courtroom, it's also in all the courtrooms. So once they all could figure out the process and we got all the forms and everything figured out with becoming a pilot program, then we brought it back down to 1 clerk in the PFA courtroom. And once in a while, we'll have a supervisor in there to make sure everything is still running smoothly. Again, we did not have extra staff. I want to reiterate that. We did not have extra staff during this time frame at the circuit clerk's office for bond calling that. We were working with the staff we had. And in addition to double dutying, they were also doing their office duties. So it was a lot of strenuous hours that honestly, we all could not have done it without them, because they have been in these courtrooms for years and they know the processes. So PFA appeals have increased tremendously. When I gave my last presentation in September, I showed that they went up, they doubled in 24. 267 additional appeals since September of 20. That's just for those 4 months. They doubled in 24. We prepared all the new forms and processes that then had to go into the case management system. In the beginning, we had everything on printed on paper so that if any changes coming up, which of course they did, every other week we're getting new changes to this or a statute that is similar to or is based on the Safety Act statute, and more changes are being made. One of the things that we really needed to up our game at the circuit clerk's office was the additional reporting that was required by the state of Illinois. So we did acquire 2 employees in our statistic data reporting division, and those were from the Safety Act that we had asked for. Those have assisted us with all this data that's required for the state, the AOIC, the list goes on and on. If we did not have those employees, we would fall behind, which then the state would not get our information, which then hurts funding going forward for all of Kane County. I do want to say though, that we are all state mandated offices. We are constitutional offices. We have mandated requirements that we have, like I have a clerk in every courtroom. We have 46 clerks that are for those courtrooms. 7 of those clerks can be off on any given day per their labor agreement. That's not including call-ins. This requires a huge shift in all of our clerks. If we're off, whatever, We have to shift people around, which requires additional training so that everyone knows processes, so that everyone can go to whichever courtroom. A huge undertaking, which we have taken on, and I feel we have really accomplished, considering how it was when I first got to the circuit clerk's office. We have mandated statistical reporting requirements that we have to do monthly. And I noticed there's going to be some changes possibly in the way hearings are conducted pursuant to the Safety Act from a new amendment that was just sent out from the Supreme Court. And I just want to read one sentence from this. Courts have been taking reasonable steps to address the operational challenges, including but not limited to adding staff, training existing staff to conduct the investigations and hearings, adjusting court schedules, reconfiguring courtrooms, addressing transportation, logistical, and security issues, and planning for disbursement of the fund established to enhance public services. Thank you.
Good afternoon. I'm Rochelle Conan. I'm the public defender. Talk about our office. So under the Pretrial Fairness Act, that was legislation that mandated that those arrested and brought to court must have an attorney. Through this act, attorneys are mandated at all initial appearance hearings, petitions to revoke pretrial release, and sanction hearings. In response to that, the Chief Judge of the 16th Circuit entered a general order which indicated that the public defender represents every person in courtroom 005 unless a private attorney appears. We are the main attorneys in that courtroom. Private attorneys do come in, but it's very sporadically. We are representing well over the majority of the individuals who pass through that courtroom. As others have indicated, to get to this point of the beginning of the Pretrial Fairness Act, it was a collaborative and a group effort of all of the justice partners. My office participated in the hours and hours of training and putting together of how the 16th Circuit would address this new legislation. Myself and my first assistant appeared at all of those meetings, while at the same time taking care of our other duties within the office. We were lucky enough and blessed enough to have a county that worked well together. The justice partners worked with a goal to make this as seamless as possible, and I believe that we did that successfully. In meetings with other counties, we often heard how far behind other counties were, how they had not even begun to talk about it, how they had not, the clerk's office hadn't talked to the sheriff, hadn't talked to the state's attorney, hadn't talked to the chief judge. We were lucky enough to be so far ahead in our ability to come together for that 18 months and get a system that works for our county. Within our office, there was also a large amount of training. This was a new system, not only for the county, but for each attorney that works in my office. We had countless hours of training for them. There were statewide trainings that many of the attorneys attended that were put on by different judges and public defenders and state's attorneys from throughout the state. As part of the Pretrial Fairness Act, our office did receive additional positions. We received 3 attorney positions at $75,000 each and 2 support positions at $33,427 each. These positions were necessary because not only was this a new legislation, but it changed the outlook of what our system looked like. As has already been mentioned, a new courtroom was added, a courtroom in which under the law, we were mandated to staff that courtroom. That first appearance courtroom, which is courtroom 005, as was indicated, is now an all-day court call. Prior to the Pretrial Safety Act, as you have heard, that was a court call which lasted maybe the morning. Sometimes it ended 10:30, 10 o'clock. The way that our office approached that courtroom prior to the Pretrial Fairness Act was that we had a rotation of attorneys. No one attorney was assigned to that courtroom. Each attorney was assigned 1 to 2 weeks a year, that court call was their responsibility. When the court call ended in the morning, they then were responsible for conducting their duties in other courtrooms and managing their court call. With the advent of the Safety Act or the Pretrial Fairness Act, that was not something that was attainable for us going forward. This courtroom was going to be an all-day courtroom, and we could not move those attorneys from their other duties for full days. So one of the positions that we received did go to hire someone who is the full-time attorney for this courtroom. She has become our expert on this courtroom and the case law that is associated with issues that arise in 005. Our attorneys arrive at 7:30 in the morning, 365 days a year. As Ms. Hill indicated, there are no holidays in this courtroom. They are in court by 8 a.m. to interview every person who has been arrested. As part of preparing to interview every person, we have to review all police reports and evidence tendered for these hearings. That can be a little bit, it can be a lot. It depends upon the case, the type of case, and the type of investigation that was done prior to the arrest. Some of the individuals that come through here, these were not instances that they were just arrested the night before. This has been an ongoing investigation conducted by the state's attorney's office and the police for possibly months. So we have months worth of police reports and evidence to review for these hearings. In courtroom 005 in the morning, conditions hearings are conducted. So these are for people who are not going to be detained in jail, but they are going to receive conditions for their release, and those hearings are conducted in the morning. And then in the afternoon, we are present for the detention hearings. The detention hearings are when the state's attorney files a petition asking to detain the individual, which means that they remain in jail without bond until the disposition of their case. Those hearings are conducted in the afternoon. On average, you can have days in this courtroom where you only have 7 or 8 people. You can have days that there's 26 people. So it just depends how many you have, how much discovery you have to go through. We have had days where we have had up to 8 people for detention hearings. Each day you come is a little bit different in this courtroom now. So in addition to courtroom 005, all of the other criminal courtrooms receive detention hearings and petitions to revoke pretrial release Monday through Friday, mornings and afternoons. So these are for individuals who already have cases pending, have picked up new cases, or who have, the state is alleging that they have violated the terms of their pretrial release. These are unscheduled matters. So we are not aware as the defense attorney that these individuals will be present on any given day. And the attorneys in the courtroom have to take care of these matters because there are time constraints, and they have to do that in addition to their other duties for the day. One of the other things that changed with the Pretrial Fairness Act is the appeals process. All conditions and detention hearings can be appealed. They can be appealed by the state's attorney or by the defense attorney. Before filing an appeal, the attorney must first file a motion for relief. And the Illinois Supreme Court has set down rules that we must follow in order to complete these motions for relief. They are not perfunctory matters. We have to list grounds for the appeal, citing to facts and case law. So it is not just a form motion. Each motion is outlined based upon the facts of that particular case. And those motions must be argued before the trial court before the case can actually be appealed. This has changed a little bit as the Pretrial Fairness Act has gone along and it has started. At the beginning of the Pretrial Fairness Act, we had a 14-day time limit that we had to file our appeals. We did not have to do as much writing for those, but we had a timeline to get them filed. At this point, with the addition of the need for the written documents that have to cite to facts and case law, we now can file our petitions up to the date of plea or disposition or trial. So while we still are appealing a great number of these, we are not under that time constraint to get it done as quickly as we had to. So we can take our time and perfect what we need to present to the court. So this is a snapshot from the dashboard that Court Services talked about for so from September 18th of 2023 until February 25th of 2025, 7,991 cases went through 005. And as you can see, the Public Defender's Office is appointed one of two ways. We can be appointed just for that appearance. So that means that we talk to the client, we conduct the conditions hearing, or we can conduct the detention hearing, and then that particular person is choosing either to represent him or herself or is anticipating hiring a private attorney. Or we are appointed fully, which means that we are the attorney on the case going forward. And as you can see from these numbers, over the majority of these cases, we are appointed fully as the attorney going forward on the case. One of the other issues that has changed for us is the weekend and holiday, a 005 call, first appearance call. Just as prior to the Pretrial Fairness Act with Courtroom 005, our weekend and holiday call was also much abbreviated. Attorneys came on the weekend, they were out by 10, 11 o'clock, and that was the end of their day. Now they are here well into the afternoon, arriving at 7:30 in the morning to get things together in the courtroom at 8 o'clock to talk to the individuals that have been arrested, and ready by 10 to conduct the hearings and detention hearings. So our duties on weekends and holidays have increased just as our duties in courtroom 005 have increased. We did our best, as everyone did, to work with the resources that we had within our office. While our structure for 005 has changed and we have one full-time attorney down there, some days that is very difficult for her based upon the number of people that have been arrested and brought to initial appearance court. In order to provide adequate representation and due process to these individuals, we have worked within the attorneys that we have in the office, and we have a backup system. So now, instead of attorneys rotating through the courtroom, they do still have a rotation schedule, but that is only to be backup for our attorney who is assigned down there. So if she has a large number of individuals who have been arrested and appearing that day, then they go down to help her do that so that we can be efficient for the court system as a whole, and so that we can adequately represent our clients. And I will then turn it over to the state's attorney.
When the PFA went into effect, we not only had to increase our staffing for that, but we also had to increase our staffing overall for the Safety Act. The Safety Act itself was rolled out in 3 different versions. The first portion really dealt a lot with law enforcement. The second version dealt a lot more with some of the laws that we have, and the last version was for the Pretrial Fairness Act. Now, you've heard a lot about the Pretrial Fairness Act, and now we're going to all-day hearings versus half-day hearings. As a result of that, we had to hire 3 felony-level attorney positions. The reason why this has to be a felony-level attorney position versus a brand-new attorney is because you're dealing with all types of cases. You could have a misdemeanor domestic battery case come before you, but you could also have a homicide case. So we needed people who understood the system, could be able to draft petitions and make effective arguments in court, whether we're asking for conditions of release hearings or whether we're asking for the person to be detained. In addition to that, we asked for and obtained one additional administrative assistant position. This is somebody who also works with us over the weekends in regards to this. There's a lot of work that goes into this that has to be done on the front end of any type of a first appearance case, especially these detention cases. The Pretrial Fairness Act, as drafted by the legislators, said that any discovery that we have in our possession, we have to turn that over to the defense attorney prior to a detention hearing. That is something that we take seriously, and we make sure to give all of that information over to defense counsel before a hearing. In the majority of these cases, we don't have a lot prior to the first appearance or when we're asking for somebody to be detained. And that's just because officers are finalizing their investigation but haven't tendered us a lot. Typically, they've tendered us a synopsis, a sworn synopsis, which is their summary and them swearing to the facts of the case, and that's what we turn over. But on top of that, our administrative assistant is also pulling the criminal history of the individual. And then we're looking to see if there are any current or other charges that would relate to whether or not we're asking for certain conditions or detention. And so the amount of work that our administrative assistants have had to do has increased tenfold. And so I do actually want to mention this. There are some cases where we have a significant amount of discovery that comes before a detention hearing. And I know that we had the 2 speakers that spoke earlier in regards to that homicide case. Now, based on pretrial publicity rules, there's not a lot that I can comment on it, but I can tell you in that particular case, we had a significant amount of discovery in our possession before we filed the detention hearing. The delays that it got towards that actual detention hearing were because we tendered thousands of pages and videos to defense counsel, and defense counsel has every right to review that prior to going to a detention hearing. And that in that particular case happens more often than one would think, especially when we, the state's attorney's office, are involved with the officers as they're investigating, providing them the legal advice necessary before charging an individual with a criminal offense. Our administrative assistant is the one that requests all that information from law enforcement, puts it into our system, and then sends it over through our Axon system to defense counsel in the most expedient way that we possibly can. In addition to that, if there's any type of a delay for a hearing, let's say defense attorney wants to ask for 24 hours just to review this and we get additional discovery in the meantime, we still have to turn that over. They still then have a right to review that, and sometimes that's where these delays happen, and our administrative assistants are the one who take that on. On top of that, we did have to increase our weekend attorney and administrative staff. The way that we did this before is we would assign people through the week, but we would pay people, much like the public defender's office, an additional amount of money to work the weekends. And frankly, that's the right way to go. As everyone who's been on this board longer than this most recent term, you know that there has been a struggle for us to keep people at my office and the public defender's office because we barely paid a living wage for any of them, let alone the attorneys who have to pay for their schooling or pay back for their schooling. We pay people on the weekends as an extra incentive so that if they choose to work, then they're actually going to get compensated for it. We then had to increase that amount that we paid because there was so much additional work that we required of them. Instead of being there for a half day, now they were there for a full day. We also had to increase the amount of people that were there because it used to just be one support staff person and one attorney. Now, because in the morning we have conditions of release hearing, in the afternoon we have detention hearings, we have attorneys who are working on those different portions so we can get this through the system as quickly as possible. The Safety Act itself also put an unfunded mandate. And this is where, again, I say to the county board, all of these requests for increases from the county board, from us to you, were made because the state legislature did not provide funding for the counties to be able to implement a law that if we didn't implement the law, we would be in trouble. This unfunded mandate came at the cost of the Kane County citizens in every county throughout the state of Illinois because funding wasn't anticipated or given. Now, that's not to say that there wasn't some funding. The appellate prosecutor's office did get some funding. Those are the people who deal with the appeals as the result of it, not my office, not any other state's attorney's office. There was a fund set up for public defenders, and I believe Ms. Conan's office got a one-time portion of that, but that's not something that's a revolving fund that she could rely on in terms of payment for her own employees. The Safety Act, because it required additional things for body cameras, redacting of those body cameras, implementation of laws, training that we now had to do, everything that you could possibly think of, we had to include additional positions, which were 4 felony level attorneys, 5 administrative assistants, which included all the now new tech support that we had to do. And we obviously had to do this in conjunction with the experience required for these positions. So we had to overall increase our budget to match what it is to bring individuals in. And so that is as a result of this law that was passed in 2021 and the economic impact that it took for us to be able to implement that completely. As you can see, this is a graph that's created by our wonderful Terry Hunt, who's always online to actually answer the financial questions, as he is by far and away the expert in what this budget looks like. But you are going to see that we had administrative positions that are in blue and assistant state's attorneys positions that are in orange. And this was an uptick that happened as a result of the implementation of the Safety Act and the Pretrial Fairness Act. Again, the impact on bond call, you're going to see without me having to detail, we had a significant increase that happened once we had to change bond call to this first appearance court based on the amount of people that we had to have there on a regular basis, and then the amount of people that we had to have there on the weekends. I do believe, I don't know if somebody from the Sheriff's Office showed up. I know they were going to send, oh, did you want to talk about your portion? So we're going to go back to that, and then we'll be open for questions. Did they have
The one question, Ms. Moser, I would ask, once the sheriff gets on speaking, if you could have Terry Hunt let us know what your salary was pre-fair trial compared to what this is, if those numbers are available.
So our entry level attorneys had $59,000, which was what their starting salary was. Their starting salary now is $75,000, which is comparable to those around us who have the same county makeup that we do. In addition to that, though, when you bump up the lowest, you have to bump up everybody else, because if you just bump up the brand new people, they're going to be making more than the other people who are within our system. So that's part of what happened as a result of all of this, to be able to keep people. So you don't have a slide apparently, but we do have somebody from the sheriff's office here if there's questions, because theirs had to increase as well as a result.
Okay, thank you very much.
Questions?
Do you want to take questions, or do you want to get through the sheriff and then we can wait? Yeah. Why don't you? Yeah.
Good afternoon.
Good afternoon.
The effect for the Kane County Sheriffs is the violations of pre-trials. Most of those are now coming back. So initially, when they get a ticket or they get released from court, at one point prior to the Safety Act, they were able to post bond. Now they are not. They are held at the other Kane County jails, and we have 3 to 5 days to go pick them up. And the sheriff's office usually do transport every day to the Collier County, to Page County, McHenry. The best one that we go to, or the most that we go to, is Cook County. And we usually bring average of 5 to 7 detainees from there because of the violation of the pretrial releases. And all of those are getting to the court and bond call the next day. That being said, the transportation team is also manned by 2 officers at a time of transport, and we don't have the manpower to do that. It has always been overtime, people that are hired back from their shift to go and do the transport to bring those arrestees back to Kane County.
Okay, is that it?
Yes.
Thank you. All right, Miss, hold on a second, Ms. Strathman, you had your hand up. please.
No.
No?
Mr. Tepe.
Okay, Mr. Tepe and then Mr. Ross.
Thank you. Thank you, Madam Chair. First off, thanks to everybody for these great presentations. They're not exactly inspiring, but they are certainly informative, okay? One of the key questions I have is that when we were going through all of this, and I remember particularly Ms. Mosser, with all of the people you were asking for, but the key thing associated with the Safety Act and the effect was because people were languishing in jail because they didn't have enough money to pay for their bond. What good has come of the Safety Act? Because it appears to me that the reverse has happened.
Well, first, I would disagree that people were languishing in jail because they couldn't pay their bond, because in 2017.
But that's what we were told, right?
Not by us.
No, not by you.
In 2017, we actually had pretrial reform. And so at that time, if you had a category A offense, which was the more violent offenses, versus a category B offense, you were treated much differently. So if you were given a bond, possibly because of criminal history, you were actually credited $30 a day towards that bond. So you could have gotten out at some point just with that credit. Frankly, Kane County was a model for the rest of this state in terms of how we did it. And I don't believe that we were holding people just because they couldn't post money. I give a lot of credit to our court services system because they have a fantastic risk assessment that we've always used, and we've always worked together to try to find out who should stay in versus who shouldn't. Now, I'm not going to say that we hadn't missed some individuals throughout the way, because I would not be a truthful lawyer/politician if I said that. Were there problems throughout the state of Illinois? Absolutely, yes. There are people in some communities who will hold everybody on a bond, and they won't really look at the risk factor versus not being a risk. So that's why this law was created. I agree with the elimination of cash bail. We shouldn't be able to pay our way out. And I say that for violent offenders, because we do have violent offenders whose bond was set at $100,000. And you know what? They posted that money and they caused more problems. So the good that this has done is it's prevented violent offenders from being able to get out, because if the courts determine them to be violent, they're not getting out. Here's the problem, though. Part of it is that we cannot hold people that we should hold because they are both a danger to themselves or others, because the legislature has not allowed us to have a wide enough detention net, which means there are some offenses that we just cannot hold. I have to tell you, I've gone to court on numerous occasions for cases not even being able to ask them to be held. For example, an aggravated battery to a police officer. If you go up and punch a police officer, I cannot ask for you to be detained, and I'm highly offended by that. If you go up and you punch a nurse, you cannot ask for that person to be detained. And the same thing goes for a firefighter or a corrections worker. And that's not the way our community should work. If it is an aggravated battery in a public place, so let's say you go up and you punch a 14-year-old kid and it happens to be in a public place, you can't ask for that person to be held. And this is what I fight in Springfield for all the time. There is good with this. There is some bad with it. And we, the State's Attorneys Association, the Chiefs Association, and the Sheriff's Association are constantly going to Springfield to advocate for these change, but we need all of our elected officials to advocate for it. And this has to be across the aisle. This is neither a Democratic nor a Republican issue. We need to change this law for the better.
Again, my point was, and I didn't mean to say that was happening here in Kane County. It was because it was happening otherwise, particularly in Cook County, where people were being detained because they couldn't have the funds. It appears to me that all of this has created a terrible effect to where we've actually got more people in jail now. So how can it be fixed?
Well, so we have more people in jail now because we're not able to hold certain individuals to provide them with the treatment services that we did before. We obviously know that Sheriff Hain put in a lot of services in our jail. So somebody who was in there with a drug issue was getting services and then released with additional services. Now we can't hold them. They're violating their pretrial release conditions, and that's how they're being held. So there are ways to expand the detention net, which is what we keep advocating for, which would allow us to ask to hold people for additional reasons.
All right, thank you. Mr. Roth and then Mr. Penesis.
Okay, Roth here. Back in November of 23 at the Judicial Committee meeting, I had raised the question to know what was it costing us for the Safety Act. And at that time, I only got a few answers. And then in August of 24, I brought it back up and I said, we need some answers. And the last answer I got was 3 million. And then in October or November of last year, Mr. Tepe gave a financial budgeting and he had 5 million. I asked him afterwards, where did he got that number? He kind of spun around in his chair. I'd love to see a summary of all the departments, what it's costing. Not that we can do anything about it, but I think we need to publicize unfunded mandates. I've been saying that for 2 years, and just recently, some of the other board members are finally starting to say that. That's our huge cost, and we don't have the money to, subsidize. So I would like a summary, if we could, of every department.
And and not to interfere with the conversation, but we're mandated to do that by the state in its current law.
Oh, I understand that, but it's still an unfunded mandate, and I think we should publicize that and, and actually start grading our state representatives, because they're saying, oh, it's a great law, but you pay for it. And that's not fair.
That's not for us to judge right now, because it's and is, and that's.
No, but I think we need the number.
So I can tell you that Mr. Hunt, who loves numbers,
Yeah.
would be more than happy from my office to be able to provide that to you.
Okay, I will set up a meeting with Mr. Hunt. Thank you.
And once you get that information, if you.
I will share, of course.
That,
Dale will be more than
Dale, happy to hear that number.
Yeah, thank you everyone for your presentation here. It's eye-opening. Yes, it's an unfunded mandate. I remember when this passed as an unfunded mandate, I know the state is hurting with their budget too. We have to live with this. I guess the questions I have are, well, the first one is, King County is an outlier out there. And I think you may have actually answered this, why our jail population has increased while the surrounding and the rest of the counties throughout Illinois, it's actually decreasing. That's because you were doing pretrial fairness in your own way, starting in 2017 then, right?
Yes.
So I think that's something that, we have these unintended consequences. We're actually paying more now for people in jail to shorter period of time. I understand that, but that's an additional cost that we didn't anticipate either. But yeah, that's the reason I just didn't understand why King County was increasing its jail population while the other counties were going down. And so I just wanted to make that point that we were doing something to address this issue beforehand. So I did have another question. I forgot what it was.
Yeah. Mr. Greip.
Yeah, thank you, Madam Chair. Jamie, help me. First of all, I want to say thank you to all of these people. I have a tremendous respect for your office and these offices and the work they do. Am I correct in understanding that these problems you've articulated, the mandates and all that, have been coming in for quite a few years now, right?
Yes.
Okay. So I'm going to issue 2 apologies. The first apology, and it's to all of you, is on behalf of the voters in Illinois for having elected people that would do this to you. That's on us, that we put people in office that think this is a good idea. So I may have voted for one of those people. I don't think I did, but I'm going to apologize in general. The second apology I'm going to issue is on behalf of the board. Not that it's my place to do this. So I'm speaking for myself, I guess. But seeing that these issues have been coming on for a long time, and we haven't done anything that I can see to equip you all for this wave that's been coming at us for many years. We still were doing stuff and buying stuff and creating stuff, especially with grant money and ARPA money and other things like that. And now, oh my gosh, we've gotten to this point where we have a big problem on our hand. So I apologize that this wasn't dealt with sooner. And I'll do everything in my power to try and help deal with it from this point on, but I don't think it's fair to you. You guys don't deserve this. So hopefully we can make it better, but you know, if next Monday doesn't happen the way some people want to happen, we got some really hard decisions to make. And would enjoying your wonderful support in helping us do that. But I just don't think it's fair to you guys, and I'm sorry.
And Mr. Gripe, I will say that, speaking on behalf of the board, before you came on board, we did support Ms. Mosser and all of our state's attorneys to increase their compensation so that the attorneys would be paid equitably. Why the staff here in Kane County government was paid internal equity. The state's attorney and the public defender wisely went out and did external equity to make sure that our attorneys were paid comparably, I believe.
All
to
my staff, not
all-
just my attorneys.
All the staff thank you for that clarification. It's important. So that they were paid comparably to other counties, meaning that we could keep our staff here because the well-trained attorneys, we did not want them being rotated or have to take on a second job unless they felt that they really wanted to do that for other circumstances, not just to make a living wage. So I think our board has been responsive, but obviously the demand that has been put upon them is quite extreme. And they're trying to do a very effective job. And matter of fact, they are doing a very effective job in representing the safety of what we do and putting on new programs as well. We have been very supportive of that and will continue to be so. But thank you for that.
Madam Chair, I've got my hand up.
Ms. Bates, I do see you.
Okay. Are you recognizing me or should I?
Yes,
wait?
I see your hand is up.
Okay, thank you. In response to Mr. Gripe's comments, I want to say that I am proud of our state legislature and proud of our elected legislators for this huge effort that they've made. I have been a supporter of the Safety Act since I first heard about it. I'm also very proud of the work that Ms. Mosser has done to help make it better. And I believe that the Safety Act has great intentions. There have been some unintended consequences, and I think Jamie's been working very tirelessly to try to iron those out. I think I'm putting words in your mouth, Ms. Mosser, but I think the Safety Act has been protecting police and protecting those arrested. So I'm proud of it. And it's been protecting fairness. And I mean, I am proud of our legislators and and the Safety Act. I'm proud of Illinois for passing this and proud of Ms. Mosser for trying to fix it. Could you please explain the last slide with the numbers on it? Could you go back one slide, Ms. Mosser?
Is that the impact on bond call? Is that what you're looking
Yeah,
for?
I didn't understand that that slide. Nope, the next one, I think.
You're going the wrong way.
It's on page 38, I believe.
Yes, that one. Could you explain that, please?
So the amount of money that we had to pay before the Pretrial Fairness Act was in yearly to be able to cover bond call was $38,675. And so Terry has broken this down to Saturdays and holidays. That's the blue pay that we have for ASAs. The orange is what we paid for support staff to be able to be there. I don't know why we have it parsed out for Sundays. That's something that Terry, or maybe it's just because we were trying to explain the difference. Now, after the Pretrial Fairness Act, we have to pay $107,825 to be able to support the Pretrial Fairness Act so that we cover it 365 days a week. And Terry, if you want to pop on, since you are the creator of this graph, you're more than welcome to if I've missed something.
So this is a year per year.
Yes.
Okay. I was afraid it was per day or.
Oh,
Okay.
per day, no.
No. In my research, I see that public safety over the last about 5 years went from 42 million to 55 million. And judicial went from 16 million to 29 million in our budgets, which is about a third more, or in judicial, almost half again as much, or almost doubled. And I know you said we need to ask Mr. Hunt, but do you think most of that came from the Safety Act? Came from
No,
PF?
I don't. I think a lot of it came from the Safety Act. I think the other portion is that we had historically not paid people within the state's attorney's office and the public defender's office and the clerks and the circuit clerks and everybody's here any type of a comparable wage, and that's what's been changing. I
And
think you
that's
all,
okay.
everybody,
Go ahead.
everybody who was on the board during that time period saw the moment that I took office, I started asking immediately for wage differences. Terry Hunt did the external equity for us. The second year I came and did the same thing, and it wasn't until the third year that I was asking for this. But I know historically, having been a member of this office as an assistant state's attorney, same job John has as an assistant state's attorney, that Joe McMahon asked for 10 years for equity raises. And during the time that I was here, we barely got raises, barely got the cost of living raises. One time we were closer to getting a higher raise, but he advocated for that for 10 years. John Barsani, who was the state's attorney before that, advocated during his term. And it wasn't until that third term in my office that we in the public defender got something that was closer equivalent to what we have in surrounding counties.
Okay, that is the right
It was a
thing to
long
do.
battle. It was a
Yeah.
long battle.
That is the right thing to do. Thank you. Thank you, Ms. Massa.
Yes. Oh, okay, Gums, and then let everybody have at least one opportunity to speak. Ms. Gums, I see your hand up.
Thank you, Madam Chair. Gums here. Sorry, I'm infectious. I did want to point out a couple of things that.
Michelle, I'm sorry, could you get just slightly closer to your
Absolutely.
computer?
Absolutely. I just wanted to point out a couple of things. Going historically, I just want to identify that the judiciary in Kane County, even pre-Safety Act, was a highlighted unit that was extremely functional and doing things differently, and they were effective. So throughout that course, the whole time that I've been on the board, we have advocated for increases in those positions. Also, we invested, I want that word to be very clear, we invested in the good things that Kane County was doing that other counties were not doing. Now, personally, I did not like the Safety Act, and I told my legislators that because of those unintended consequences. But we'll work those out. But I just really, really want to highlight that throughout the entire time that I've been here, I think 99.9% of the time, every board member supported the good things that Kane County was doing, and we all invested in that. And I think we should continue to invest in that because we're doing better than most counties in this state. And also, the entire country is looking at us for the things that we do good. I don't want that to go understated. I think it's extremely, extremely important that we identify that we are creating good public safety for this county. And we do that by investing in it. And I want to thank everybody for, doing all this work, but I just really want to highlight that.
Thank you, Ms. Gums.
That's all I
Ms. Gar-
got.
Thank you. Ms. Garcia.
Well, me being the newest one, I just want to go ahead and say thank you to everybody, especially for all the job that you guys are doing. Trust me, there's nights where I can't sleep thinking about how can I help and how can I make a difference moving forward. Sometimes we make decisions in times where we think that that's the right decision. And right now we're one of those positions that things are not working the way that we thought they were going to be working. So I know that you did an amazing job trying to retain and get more staff. And that's number one for anything to be doing, to have
a great system. We have to have retention. We have to have people. We have to make them come in and be happy of what they're doing and not being frustrated, overloaded, and feeling like nobody's listening to them. So around the area, do we have any data on how other counties are doing on retention, and that can we compare those, or can I just go in and get that information?
Unfortunately, I don't think anyone keeps that in the way that we would all like to see that. I can tell you that I speak with the other state's attorneys. We're on weekly calls with each other, especially closer to central and southern Illinois. They're having a really hard time keeping people and hiring people. So they've had spots that have been open and aren't able to fill them. One of the things that we presented at one of the past board meetings when we were talking about this is fewer and fewer people are going to law school. Now, obviously, that makes them much smarter than Ms. Conant and I, who are still probably paying off all of our debt. But fewer and fewer people are going to law school. And so when you have less people, they're going to go for the higher paying jobs than they are going to come to the government, despite the great things that we can bring, like having a wonderful pension, having government holidays. I can tell you, I love the 2 that my kids are in school. Well, I don't have to be at work. And so we have great benefits. It's about advocating for that. There's many different factors, but I don't think you can get that in actual data. I can tell you my colleagues have expressed to me that they're suffering from retention and hiring throughout the state of Illinois.
Thank you.
All right, I think everybody had a chance to speak once. Mr. Hennessy, and then
I
Mr.
did
Wright.
remember my other question, but yeah, this is a decades-old problem that our state's attorney is addressing. It's finally being addressed, and you throw the Safety Act on top of there, and it's the perfect storm right now. And yeah, I mean, we're going to have some tough choices to make, obviously, coming forward possibly. But the question that I forgot to ask you was, there was something in the Safety Act regarding like isn't it, and I'm not sure if the wording is correct, danger to the general public, right? Someone striking a police officer, some of these cases that you can't detain. Can you kind of describe that and why we can't detain some of these people? That seems obvious to me that it would be a danger to the society.
Correct. So the problem is the way that we created a law in Illinois is we fashioned it close to what New York did, where they created a detention net. So when this law was first passed, they had 6 subcategories of crimes that could be detained. Now, the obvious ones are there: murder, sexual assault, domestic violence. Through our advocacy, we were able to increase that to 10 different categories of detainable offenses. But if the offense isn't listed as a detainable offense, it doesn't matter if they are dangerous or not. So I give Bob Berlin's example. He's our DuPage County State's attorney. They had a person who threw a brick through a window, caused felony criminal damage amount of property. Criminal damage to property is a non-detainable offense. And we can kind of get on board with that if you think about it, because it's criminal damage to property. However, without allowing us to argue a dangerous standard, that's problematic, because that individual had a manifesto on them that said that this is the first in a series of things that they're going to that eventually would cause the death of an individual. That's a person we want detained. But we, the state's attorney's office, cannot ask for that person to be detained, even if on their person they had something that said, I'm going off and killing so-and-so after this. It's because of the way that it's drafted. It is easily fixed if we just follow the New Jersey law. The New Jersey law doesn't have a detention net, but still provides a standard that we have to meet. It raised the level of what we have to prove, which is beyond preponderance of the evidence. It used to just be more likely than not, this is the reason why they're a danger. Now we have to prove it by a clear and convincing evidence standard. And we have to prove that no condition or combination of conditions would allow the community to be safe. So a domestic battery, yes, we can prove they're a danger because they beat up their spouse. But can we put them on EHM or some other type of home arrest? Can we put them in some treatment program to lessen the danger that they would be to the community? So that's the problem, is that unless it's specifically enumerated that this is a detainable offense, there's nothing that I can do to argue, nor, and this is important because this was the lies that were put through that election period, can a judge. A judge cannot say, oh, I just disagree with this, I'm going to hold this person, because if they do, they're going to get in trouble.
So are your fellow state's attorneys going down to Springfield to increase the number of offenses that can be added to this?
Yes, I'd like to say now that there's 101 of us out of 102 that are on board with increasing this detention net, and we advocate for that. We rewrite it. We have meetings. Again, you'll see me in Springfield. I'll put it on Facebook as proof that I'm going to Springfield today. So yes, we advocate for this all the time.
Well, thank you.
Thank you. Mr. Gripe.
Thank you, Madam Chair. I could think of a quick solution. That's get Jamie elected governor. But
No, thank you.
yeah,
Absolutely not. No,
Chicken.
not a chicken. I'm smart.
But
So no.
I did want to clarify. I didn't mean that everything that comes out of Springfield doesn't make sense. You're people smarter than me, which includes the two of you and everybody back there and most of these people. But when the legislature sends something to us or at us that's unfunded, that's not right. And they've been getting away with it and we need to stop them from doing it. I don't know how. Just as we would never do that to the people in King County. We wouldn't say to them, you have to start doing this or that, and you got to cough up the money to do it. So, but it's gonna keep happening. So the board needs to anticipate when those things are coming and where we're going to get the money to help you guys do what you say you need to do. So that's my point. We've got to be on the same team and we got to think ahead of the ball instead of, a little later. So, but thank you guys. I just glad I don't have to do what you do.
It's little after 4:30 and the meeting is supposed to come to schedule to about 4:30. I will, if there's no other questions, Mr. Tepe, last one.
Thank you, Madam Chair. It appears to me that all of the presentations that we heard today really affected the impact of their organizations due to this Safety Act all. None of that's going to change. Am I correct? We're still going to have bond court every day. We still need the extra courts. We still need all of the extra personnel. Your department and Rachel's department Rochelle's department have to prepare reports in very short time period.
Correct.
That's going to go on for the foreseeable future.
Correct. So come April 1st, referendum passed or not, also my birthday, everybody, in case anyone's thinking of gifts ahead of time. It makes sense, right?
A past
we s-
referendum.
Yes, we still have to do this. This law isn't going away. Shameless plug that it was my birthday, so.
Madam Chair, may I make an announcement? Ms. Bates?
Yes, Ms. Bates, yes, please. And that'll be
Um,
the last thing.
Okay, this will close we can close out with this. I've been informed by the state's attorney, the assistant state's attorney, that the town hall scheduled for this evening at the Sugar Grove Library needs to be canceled because it's a polling place.
Exactly. So
please, anybody watching this on YouTube or anybody who thought they were going to go today, it's been canceled.
Okay, very good. Okay, thank you. Thank
Do you
you
have
for
a
letting
point
us
of
all know
order?
that.
If I may, when you.
Davis, we heard you.
Thanks, Cliff.
Is it germane to this?
It's germane to the meeting.
All right.
If I may. So I apologize to the presenters and the rest of the board for 8 of us being late to this meeting. We had a forest preserve meeting at 2:00. It was news to many of us that the meeting had been moved to 3, and actually it still shows on the county calendar as 4:00. And Jane and I were going back and forth about that. But anyway, I apologize for that. I'm just a little disappointed that this meeting went ahead without 8 people. I know we don't need a quorum because we don't vote, but I didn't get any notice that this meeting had been moved. Mr. Tepe was so kind to send out meeting notice that the ARPA meeting is being canceled this week, but there was no other email about this. And we're all sitting in that meeting over at the Forest Preserve saying, oh, they'll wait for us. They'll wait for us. So no disrespect, we thought we would be getting here and the meeting would start. So yeah,
Was an email. There was an email that was sent out.
I never saw it. Any rate, it's just, that we weren't here and it went ahead.
It's was totally fine. We knew that there was another meeting occurring. So I would like to just close this. It was mentioned that no one here in Kane County would dare to do anything like that. Put an unfunded mandate upon our taxpayers. As a bit of levity, welcome to parenthood. With that, may I have a motion second to close this meeting? No, we just, okay, that's it. We don't need a motion. Everyone have a great day.
Amy. So